The possibility of indicting a former president is a controversial issue in the United States. Some argue that a former president deserves immunity, while others believe that they should be held accountable for their actions, just like any other citizen. In this article, we will explore under what conditions a former president can be indicted, the intricacies of the laws regarding this, and how the sentencing would be. According to the Constitution, the President of the United States has immunity from criminal prosecution while they are serving in office. But what happens when a president leaves office? Can they be indicted for crimes committed while they were in office? The short answer is yes, a former president can be indicted, just like any other citizen. However, there are some conditions that need to be met before they can be held accountable for their actions. Firstly, the statute of limitations must not have expired. The statute of limitations is the time limit within which charges must be brought against a person. After that time limit has expired, the person cannot be charged. The statute of limitations varies depending on the crime, but for federal crimes, it is usually 5 years. Secondly, there must be sufficient evidence to bring charges against the former president. In other words, there must be probable cause to believe that the former president committed a crime. A grand jury must be convened to assess the evidence and decide whether to issue an indictment. Thirdly, the crime committed by the former president must be within the jurisdiction of the court where the indictment is issued. This means that the crime must have been committed within the geographic boundaries of the court's jurisdiction. Assuming these conditions are met, the former president can be indicted. The indictment is a formal accusation of a crime, and it sets forth the charges against the defendant. The former president can then be arrested and brought before a trial court to face charges. The intricacies of the laws regarding indicting a former president can be complicated. For example, the Department of Justice has a policy of not indicting a sitting president. This policy is based on the belief that it is too disruptive to have a sitting president facing criminal charges. However, this policy does not apply to a former president. It is also worth noting that the process of indicting a former president can be particularly fraught with political considerations. If the former president is from a different political party than the current administration, there may be a temptation to use the legal system to pursue political goals. This is not how the justice system is supposed to work, and it can undermine the public's belief in the rule of law. Assuming the former president is indicted and found guilty, the sentencing would depend on the severity of the crime committed. The judge would consider a variety of factors, including the seriousness of the offense, the defendant's criminal history, the impact on the victims, and the need for deterrence. The punishment could range from probation to life imprisonment. In conclusion, while a former president can be indicted, there are conditions that must be met first. The evidence must be sufficient, the statute of limitations must not have expired, and the crime must be within the jurisdiction of the court. If these conditions are met, the former president can be arrested and brought to trial. If found guilty, the sentencing would depend on the severity of the crime. The process of indicting a former president can be fraught with political considerations, but it is important that everyone is held equally accountable for their actions, regardless of their political status.